Hello, future lawmakers. Welcome back to another insightful session of Focus Lexicon. And I hope your labor laws preparation is going really well. And अभी labor laws दोस्तों सारे के सारे जो हैं वो change हो चुके हैं. And the biggest problem is in the supplement that there is no master index, there is no illustration. Code on wages is a technical law. उसके अंदर सारा पेमेंट ऑफ ग्रेचुटी किस तरह से कैलकुलेट करना है, सेट ऑफ के किस तरह से प्रोविजन लगने, टैक्स प्लानिंग किस तरह से करनी है, ऑल दिस टॉपिक्स हमारे मॉड्यूल के अंदर दे तो दिए गए हैं लेकिन उसके बारे में कोई क्वेश्चन नहीं है. सो देयर इज लॉट ऑफ डिलेमा इन द स्टूडेंट्स की सर हम इसको अटेम्प्ट कैसे करेंगे. तो बच्चों बिल्कुल भी टेंशन लेने की आपको जरूरत नहीं है. फोकस लेक्सिकन लेबर लॉ आर्किटेक्ट, दिस बुक इज अल्टीमेट सॉल्यूशन फॉर यू. दिस बुक इज अल्टीमेट सॉल्यूशन फॉर यू. इस बुक के अंदर पहले तो हमने आपको एक मास्टर इंडेक्स प्रिपेयर करके दिया जहां पर आपको सिर्फ पेज नंबरिंग करनी है. इंडेक्स पूरा बन गया दोस्तों. And we have arranged this in a method that it is very easy for you to spot the topics, because law is never read in isolation. Law is always read in context. Law हमेशा context के साथ पढ़ा जाता है. Law कभी भी isolation के अंदर नहीं पढ़ा जाता. हमेशा law को context के साथ पढ़ते हैं. So we have designed the whole context for you. Like if you are given opportunity to draft law for this country, then what you will do? Then how you will draft this labor codes? So you will draft, like, first of all you will plan the establishment. You will define which type of establishment is there, what type of registration it should have, and what type of safety norms it should follow. First of all you will plan the establishment. Like, this is very common sense. After you plan the establishment, after you have registered your establishment, now the second step that you will do is you will employ the people. You will employ the people. When you will employ the people, they are not going to work for free. Obviously, they are not going to work for free. You have to pay them wages, you have to pay them salary. So after establishment, second thing what you have to draft is code on wages, that you have to make payments to all your employees and all your workers and your all personnel. Then after, is paying salary enough? Is paying salary enough for living a life of dignity? Answer is no. Everyone wants social security, that there should be obligation. Lawmaker does not make law in isolation. First of all, they find what is necessity. First of all, they find what is the necessity. Why this law is required to be made? Then they make a norm that to implement this law, you have to follow such and such norms. After making that norm, it is not a guarantee that person will follow that norm. So government creates an obligation. Lawmaker creates an obligation to follow that norm. They find the necessity, then they create a norm. For fulfilling that norm, they make a mandatory obligation that leads to fulfillment of that norm. So third law that you are going to draft is social security. Code on social security. You are going to create an obligation for the employers to mandatorily pay them wages, mandatorily pay them the salary. So that you are defining the provisions for EPF, ESIC, so that employers, if employers are fulfilling their obligations, then by default they are fulfilling the norm also. By default they are fulfilling the norm also. Then after social security, sir, you have provided everything in favor of laborers only. Now what if they raise a dispute? What if they raise a dispute? They form a cartel and do a strike. What you can do? So you have to protect your establishment also. You have to protect the establishment also. You have to also provide a dispute resolution mechanism. So next code you will draft is industrial relations code. Next code you will draft is industrial relations code. How you will handle strikes? How you will handle trade unions? How will you resolve the disputes among your workers and your employees? So after all this, so we have arranged this such a master flow we have given. Okay, so it will help you doing a contextual study. Like, do not study in isolation. Never study law like this, section number 1, section number 2. Don't study law like this. Law should be studied in context. Okay, so we have provided the whole sequence and whole chronology. Now after drafting all the laws, after following all the laws, now you are enough eligible. You are enough eligible to mark the compliances. Now you have studied all the laws. Now you are enough eligible that you can find their compliances. So after that, step number 5 is you have to study the compliances. So we have arranged the chapter number 9 at step number 5, that industrial and labor laws audit. You have to study the compliances and implementation schedule. Then after doing your compliances, what you will do? You will keep the records. So then after you have to study the chapter number 7, labor law simplification of procedure, furnishing return and maintaining register by the certain establishment. So like this we have arranged your study material. Okay, then this is your master index. then come to the illustrations. I was telling you about illustrations. So in code of wages, there are so many illustrations. See this is your code on wages. In institutes module, they have given plain sections. Okay, 264 or 265 pages supplement is there, but they have just given plain section, no case law. They have not mentioned any case law, but labor laws and practice paper is case law based, and they ask technical problems. So to deal with technical problems and case laws, we have drafted this book in such a manner that you are able to practice also, you are able to practice questions also. So we have drafted many questions in this. Okay, on code of wages we have drafted section wise questions. Okay, you will be finding illustrations, and you will be finding questions that you can directly write in exam. Okay, this is ready to write answer format. You need not to think, okay, sir, I will read this, then I have to make a summary, then I have to write it in an exam. You need not to worry about that. We have already given you ready to write answer format. We have already given you ready to write answer format. Then we have provided you illustrations that how to calculate minimum wages, basic wage rates. So you should avail this. You should avail this book, like exams are near, and it will take a few days to deliver also. So you should avail this book, and everything has been compiled in this book. Okay, and exam oriented sessions are going on, and you can tell me in the comment box also that if you want anything specific in this exam oriented session, then we will be providing that also. Okay, so this is all your illustrations. We have given all your illustrations. Then there is a special thing in code of wages. There is a special thing in code of wages, that is a provision for set off and carry forward. So for that also we have designed so many questions. Like how you will carry forward, how you will set off, then minimum wages, how you will calculate minimum bonus, how you will calculate maximum bonus, and how you will be making your accounting for that. Okay, so we have covered these all questions, and you will be finding it really very useful and meaningful. Then we have covered a real life thing also, that for example, now tomorrow you will be employed in some company, you will be the company secretary of some big company, then you will be getting a CTC. So we have prepared a model CTC using these new laws. So you will be very conversant with how actual CTC is drafted. So this is a very technical book also, very technical resource also, and this is very useful for your exam also. So we have arranged this section wise and all this in ready to write answer format. Okay, then chronology, and then all the steps that how to calculate. So everything is included in this book. So now let's get back to our topic. Let's start the session, and from where we left in our last class, we have completed up to mines and minerals. So today we are going to start from the definition of dock work. Now what is a dock work? See this. Let's just come to our topic. My dear friends, make sure you subscribe to our channel and do like the video and do share it in all the groups. And if you are finding it useful, please let us know in the comment box. So we will be continuing from here. Dock work. Mode of notice and duties of employer was there. Machinery, definition of hazardous was done, and we have to start from dock work. Yes, we have to start from dock work. Okay. So this is the ready to write answer format. Need not worry. Open book paper. It is open book paper. You need not to learn anything. Okay. You just need to read and mark the index. You just have to read and mark the page number in index. That is only your work. Okay. बाकी हमने आपको सब कुछ ready to write answer format के अंदर करके दे दिया है. So definition of dock work, how you will write this in light of provision of section 21S of OSHWC Code. Definition of dock work, meaning dock work means work in or near the port related to loading or unloading cargo, movement of cargo, storage of cargo. Like dock work is not only that it is related to only place where cargo is placed. It relates to all the activities that are happening around that cargo, like loading, unloading, movement of cargo, storage of cargo. Cargo movement may be into or from ships or vessels, port or docks, storage places or landing places. Like cargo will not be placed at one place. Okay, you have to shift it also, you have to send it also, you have to receive it also. So all that activity that is covered under dock work includes the following work: ship preparation work, works related to preparing ships and vessels for receiving cargo, discharging cargo, leaving the port, and repairs and maintenance, repairing or maintaining holds, tanks, structures, lifting machinery, storage areas, either on ship or in docks. Then cleaning and surface work, chipping, painting or cleaning hold, tanks, structures, lifting machinery, storage areas. All these things are covered under dock work on ships or in docks. So see this, like cargo is placed here. This is also dock work. Cargo is being transferred. This is also dock work. Now it is being lifted. It is also dock work. the ships and machines are being repaired, they are being loaded, they are being unloaded. So this is also dock work. This is also dock work. Now places around the cargo, this is also covered under dock work. You are shifting one cargo from one ship to another ship. During your journey only, you are transferring the cargo from one ship to another ship. That this is also dock work. Okay, all the people employed in this ecosystem are covered under the definition of dock work. Like you are repairing the machinery, you are loading, you are unloading, you are checking, you are planting, anything that is covered under dock work. This all thing is covered under dock work. Next is, what do we mean by cargo? Cargo includes anything carried or to be carried, mode of transfer, ship, vessel, or vehicle. Anything that carries or is going to carry, that is cargo. Okay, like it can be a ship, it can be a vessel, it can be a truck, or it can be something. Okay, term cargo is very, very wide. It covers goods already in transit and goods intended for transport, includes all type of movable goods, Next is definition of building or other construction work. So how you will write this? In light of provisions of section 21H of OSHWC Code 2020, means construction, alteration, repair, maintenance, or demolition related to infrastructure works, buildings, streets and roads, railway and transway, airfields, water or irrigation works, irrigation and drainage works, embankments and navigation works, flood control and storm water drainage, water works and water distribution channels, then power and energy works, generation, transmission, distribution of power, oil and gas installations, electric lines, then communication structure, internet towers, wireless radio, televisions, telephone, telegraph system, overseas communication system. So all these things are covered under your building or other construction work, like major engineering structures, dam, canals, reservoirs, water courses, tunnels, bridges, viaducts, aqueducts, pipelines, towers, cooling towers, and transmission towers. So all these things are covered under your building or other construction work. However, there are some exclusions also. The term does not include construction work related to factory or mine. If construction is going in a factory or mine, it is not covered under building or other construction work. Construction work for own residential purpose. For residential purpose, if someone is constructing, that is also not covered under building construction. Okay. Then if the total cost, residential purpose, maybe there are two situations. If the total cost does not exceed 50 lakh or higher amount notified and worker limit is within the prescribed number notified by the government, then it will be not covered under building. Okay. Now, if you are making a multi-floral flats, if you are making multi-floral buildings, and the cost is more than 50 lakhs, so like properties cost obviously is more than 50 lakhs. So that will be covered under building work, because you will be employing the contract labor there, you will be employing so many personnel there, so many workers, so many engineers you will be hiring there. So that will be covered under your building construction work, if that is for commercial purpose. Now, building worker, in light of the provisions of section 21I OSHWC, building worker means a person employed for hire or reward. Hire means monthly, reward means wages. In building construction work, nature of work, he may be highly skilled, he may be skilled, he may be semi-skilled, he may be unskilled. He may be manual, technical, clerical. Employment may be express or implied. Employment may be express or implied. Now, what is express employment? Express employment is that you have duly signed that person on employment, like you have made the contract, you have employed him through your offer letter, and everything is done in a formal and structured way. Implied employment is that ये चाचा जी का बेटा है, रख लो, घर पे कुछ नहीं करता, आपके पास आ जाएगा तो इसको कुछ पैसे भी दे देना. So that is implied employment. Exclusion does not include a person employed mainly in managerial capacity, supervisory capacity, and administrative capacity. Managers, your supervisor, your administrator, like all the boss people. Boss people are not included in this definition. This definition. Next is definition of plantation. In the light of provision of 21ZX OSHWC Code, definition of plantation: land used for certain crops, specified crops, land used for intended for growing tea, coffee, rubber, cinchona, cardamom. Do you know what is cinchona? This is used for treating malaria. This is used for treating malaria. And stem of this flower is used. Stem of this flower is used. Then cardamom, that is elaichi. Area must be 5 hectares or more. For a plantation, the area must be 5 hectares or more. Land used for any other plant, area 5 hectares or more, person employed during preceding 12 months, declared as plantation by state government, notification with central government approval. Then explanation, if land used for such crops is less than 5 hectares, but it is contagious to another land and both lands are under same employer and total area is more than 5 hectares. For example, someone is planting cardamom in his plants in his field, and the place where he is planting the cardamoms or he is planting the tea, that area is less than 5 hectares. However, he is owner of a total land plot that is more than 5 hectares, and that is conjoining land. All the lands are together. So that will be considered as plantation, because that nearby area is also affected by that plantation. So government then it will be treated as plantation. Government declared plantation. State government may declare any land as plantation by notification. Applies even if the area is less than 5 hectares. State government has the power to declare any plant as plantation even if the area is less than 5 hectares. Proviso, such declaration cannot apply to land less than 5 hectares existing before the commencement of this code. This power to central government exists only after commencement of this code. However, if there is something like before enforcement of this code, then central government does not have power to declare that. Central government can declare that after commencement of this code only. Now, associate premises, when this code commenced, sir, 21st November 2025. After this, government can notify any land to be covered under plantation. Associated premises include the premises connected with plantation such as offices, hospitals, or dispensaries, schools, and any other related premises. Exclusion, factories within the plantation premises is not included in plantation definition. If there is any factory in that plantation, that will be not covered under your definition of plantation. See, so this was your building and construction work. Now this is your plantation. So like this can be a affected area. For example, you are doing your plantation here, and this land also belongs to you. So this land is contagious. Like if you are growing tea here, so it will affect the land here also. So like it will affect the fertility of the land. Okay, so that's why it is covered under plantation. Okay, like this auntie is doing these things. This is all covered under plantation. Okay. Plantation is also ecosystem. Like you cannot say anything in isolation as a plantation. Now, duties and responsibilities of owner, agent, and manager of the mine. In the lights of provision of section 7 OSHWC Code, duties and responsibilities of owner, agents, and mine. Responsibilities of owners and agent. Owners and agent of mine are jointly and severally responsible for making the necessary financial provisions. Owners and agent of a mine are jointly and severally responsible for making financial provisions, taking necessary steps to comply with the code and related rules and regulations. Liability for contravention. If any person violates provisions related to mine, the following person are also deemed guilty unless they prove due diligence. Supervisory officials responsible for duties related to violated provisions, manager of the mine, owner and manager of the mine. Now see this, if any person violates the provision related to mine, the following purposes are also deemed guilty unless they prove due diligence. Who are deemed guilty? Supervisory officials, manager of the mine, owner and agent of the mine, person appointed to carry out responsibility under section 24. Sir, what is section 24? Section 24 is welfare benefits. Section 24 is welfare facilities in establishment, like they have to provide first aid kit and all that. They have to provide नहाने की जगह अलग देनी है, धोने की जगह अलग देनी है. So that is provided under section number 24. So they will be held guilty, but they will not be held guilty if they have proved due diligence to ensure compliance and reasonable steps taken to prevent the violation. That they have taken steps to prevent that violation and they have done their due diligence properly. So then they will be not covered. They will be not held guilty. Okay. No defense. Owner or agent cannot claim defense that manager or officials were properly appointed or a person was appointed under section 24. Owner or agent cannot claim that we have appointed the person, so the responsibility lies on that person. Owner will be held liable. Then definition of owner. Who is the owner? We are saying that owner will be liable. Now, who is the owner? In lights of provision of section 21 ZW OSHWC Code, definition of owner. Owner means a person who is immediate proprietor, lessee, occupier of the mine or any part of it. If mine is managed by liquidator or receiver, then they are treated as the owner. Immediate proprietor is the owner. Lessee is the owner. That person who has taken the land on rent is deemed as owner. Now, occupier of the mine of any part of it, that is also owner. Liquidator or receiver, that is also owner. Exclusion does not include a person who only receives royalty, rent or fine from the mine. If the person is owner of the mine and he has given that mine on rent and he is just liable for that rent only, he just collects the rent, he does not bother about what is happening in the mine. So that will be not considered as owner. Next is merely proprietor subject to lease license. That person is a proprietor and he has given his land on lease. He has given his land on lease. The person who has given his land on lease, he is not the owner. The person who has taken the land on lease, that is the owner. That is the owner for the purpose of mine, for the purpose of this section. Is only owner of the land, soil, and not interested in minerals. That person does not know that his land is rich in minerals. He does not know. He just know that it is a piece of soil. It is a piece of land. So the person who is unbothered with mines, so that is also not an owner. Then special provisions, contractor or sublessee. Contractor or sublessee working in the mine treated as owner for liability purpose under this code. But this does not remove the liability for actual owner. The person, for example, someone has given the land on lease and this person subleases the land. This person subleases the land or subcontracts the person to another contractor. Then the contractor or sublessee working in the mine, they will be treated as the owner for the liability purpose. But this does not remove the liability from the original owner, from the original lessee also. That the person who has taken the land on rent and then he has further given the land on rent. So for the purpose of this code, the person who has given the who is the first who has taken the land on rent at first instance, that will be also owner, and to sublessee, to whom he has sublent the land, that will also be considered as owner. They cannot write off their liability. Definition of agent. Now, who is an agent? In the light of provisions of section 21C of OSHWC Code, definition of agent meaning that agent means any person who acts on behalf of the owner and is involved in management, control, and supervision or direction of the mine. Person may be agent, may be an agent, whether formally appointed or not. Cover the person who is involved in whole mine or any part of the mine. That is covered under your agent. Duties of designers, manufacturer, importers, and suppliers. Duties of manufacturers, importer, or suppliers. So section 8, duties of designers, manufacturers, importer, or suppliers. General duties, articles used in establishment. Every person who designs, manufactures, import, or supplies articles shall ensure article is safe and without risk to workers' health when properly used. Like this is the very, very general duty. Conduct or arrange necessary tests and examinations. Provide adequate information regarding use of article, purpose for which design or tested, conditions for safe use. Then there is a proviso, imported articles. Importer must ensure that article meets Indian standards, or if foreign standards are higher, then comply with those standards. If no Indian standard, then comply with the standards of exporting country. So like importer should understand that you have to follow Indian standards. Like if the another country is having higher standard than Indian standard, then you have to follow that higher standard. If there is no Indian standard, comply with the standards of exporting country. The country which is exporting it to you, you have to follow their standards. You have to follow their standards. Additional duties, must comply with regulations prescribed by central government in consultation with National Occupational Safety and Health Advisory Board. Now, this advisory board is also set up under this act. We will be learning this under next chapter is for your National Health Advisory Board only. So, okay, section number 16, we will be studying about it. Then research obligations, may conduct research to discover risk, eliminate or minimize risk to worker safety, health. No repetition of test, no need to repeat the test, research already done if it is reasonable to rely on existing results. Then scope of duty, duty applies only to activities done in course of business and matters within the control of such person. Next is duty related to factory. What are their duties related to factory? Installation of articles, person installing, erecting any article must ensure that article is safe and they do not pose any health risk when used in a factory. Substances used in a factory, person who manufactures, imports or supplier substance shall ensure substance is safe and without health risk. ये सर इसके अंदर इतनी सारी health conditions क्यों दी गई हैं यार? एक्चुअली क्या हो रहता है ना, the workers who are engaged in the factories, like उनको क्या रहता है यार, उनको इतना नहीं पता रहता. Like they are not very much literate. Okay, they are either wage workers, they are either laborers, so they are not that much literate. उनको क्या रहता है ना यार, उनको समझाना पड़ता है बार बार, उनको समझाना पड़ता है कि भाई इसको सही से यूज कर, इसको सही से यूज कर. क्या हुआ था यार, एक जगह पे ऐसे इंडस्ट्रियल एरिया के अंदर देवर एंगेज्ड इन अ कॉटन फैक्ट्री, आई थिंक कॉटन और पता नहीं हैंडलूम की फैक्ट्री थी, ऐसा कुछ था, कॉटन फैक्ट्री थी शायद. सो दे यूज हाई प्रेशर पंप्स टू fill that cotton or something, like they use high pressure pumps to eliminate the impurities from the cotton. That pump is very high pressure pump. अब यार यहाँ पे आपको सेफ्टी इंश्योर करनी है, अब आपने वहां पे बंदे एम्प्लॉय कर दिए, वो बंदे थे थोड़े से शरारती, they were naughty, they were very very naughty. One person did was that he inserted that high pressure pump in some private part of another worker and started that, and that caused death of that person. Sorry, I'm laughing on someone's death, but this is the real case that happened that I have seen. You can see that in news also, that some person put that high pressure pump in some private part of another person and then started that pump, and due to high pressure explosion that person died. That person died. So you have to really maintain, you have to educate your workers, you have to tell your workers that please don't play with these things, these are very very risky things. And they were adults, they were not like they were not adolescents, or they were not they were not kids, they were full grown adults, and they did this misbehave. So you have to really ensure that all the necessary tests and examinations are also that are established in that your factory or your establishment. Ensure test results plus safety conditions are available in the factory. Ensure safe use without health risk. Research on substances. Person manufacturing substance must conduct necessary research to identify risk, eliminate or minimize risk to health and safety. Next is proper use. Article substance is not properly used if used without following instruction or advice given by designer, manufacturer, importer or supplier. So you have to follow their instructions. You have to make sure that your workers are following the instructions given by the designers, manufacturer, importers or suppliers. Then explanation. Article includes plant and machinery. Article includes plant and machinery. Substance includes natural or artificial substance, solid, liquid, gas or vapor form. Substance for factory use means substances were used by workers or not. Then duties of architect, project engineer and designer. Section 9. Duties of architect, project engineer and designer. Safety at planning stage. Architect, project engineer and designer must consider safety, health of workers at planning stage. Now when they are planning their assignment, they must ensure that the workers who are working, they are safely handling that stuff. Applies to workers involved in erection, operation and execution of the project structure. Avoid hazardous design. Must ensure that no dangerous structure, process or materials are included in design. Should avoid anything hazardous to the workers' health and safety during erection, construction, operation and execution. Like any person who is an architect, who is a project engineer or who is a designer, he should make sure that he is making a design that is not injurious to someone's health, is not injurious to someone's health. For example, someone is constructing a building, and that he is instructing that only make it on 3 pillars, don't use the 4th pillar, make it stand on 3 pillars only, use some angles there. So using that angles will cause a risk. So he should make sure that. And another example, for example, if an engineer is working on a construction site, he has seen that so many open electrical wiring is going from that area. So many open electrical wiring is going from that area. Now, if they start constructing there, and the iron rods they are using, if they touch that electric rod, then it will cause trouble. So he should make sure that iron rods are not openly in contact with that electrical lines. He should make sure that iron rods are very very far away or at an appropriate distance from that open electricity wiring, so that their workers are safe. Next is safety in maintenance. Must consider safety aspects during maintenance and upkeep of building structures, especially where maintenance involved. Notify hazard by appropriate government. Now, who is an appropriate government? Definition of appropriate government in the light of provisions of section 2(1)(d) OSHWC Code. Definition of appropriate government. Central government is the appropriate government for establishments run by or under authority of central government. Like if any establishment is run by or under the authority of central government, then central government is the appropriate government for them. Controlled industry specified by the central government, like specific sectors, railway, mines, oil fields, major ports, air transport service, telecommunication services. Then organization like banking companies, insurance companies established by Central Acts, corporation under Central Acts, CPSUs, central public sector undertakings, subsidiaries of CPSUs, autonomous bodies owned, controlled by central government, contractors of all the above establishment, contractors of all the above establishment. Central government is the appropriate government for them. Okay, proviso, even if the central government holdings become less than 50%, central government remains appropriate government for CPSU. Like this is your CPSU. If the shareholding of central governments fall below 50%, then also central government shall be the appropriate government for this PSU purpose. Okay. Now state government is appropriate government for factory, motor transport undertaking, plantation, newspaper establishment, BD and cigar establishment, other establishment not covered under clause 1 based on the location of establishment. Explanation: for the factory situated in a state government is the appropriate government for occupational safety, health and working conditions. For any factory, like it's very simple. Like if you want to understand it from a formula, like all the private organizations, your factory, your mine, your any business industry which are covered under any state, the state government is appropriate government for them. And all your regulated industries like banking company, insurance companies, and all your CPSUs and all your aerospace and all that thing, they are central government is the appropriate government for them. Central government is the appropriate government for them. Okay. Next is controlled industry. Now, controlled industry is being talked here. Like controlled industry is specified in central government. Now, what is a controlled industry? Like this, we have to do contextual study. Okay, we are finding definitions from definitions. Like if I make you study from the section number 2 itself, na, like first definition is agent, then is another, then is another. So you will not be able to make a context. Now we are doing contextual study. We have studied appropriate government, then we found a word controlled industry. Now we will be studying controlled industry. Law is made in this format only. Law is made in this format only. Law is drafted in this format only. They define definitions from definitions. They define definitions by their use. They define definitions by their chronology. They do not define definitions first and then draft the sections. They draft the section first, then as per their requirement, they define their definitions. At last, they just arrange the definitions in alphabetical order. Okay, so this is the process of making law. So next is controlled industry, means any industry conditions control declared by central government under any central act in public interest. Like any industry on which central government declares it control, that it is in our control, that will be deemed to be your controlled industry. That will be deemed to be your controlled industry. Then what is a major port? Major port means a major port as defined under clause 8 of section 3 of Indian Ports Act. Then metro railways means metro railway defined under Metro Railway Operation and Maintenance Act 2002. Notice of certain accident. Section 10, notice of certain accident. If an accident occurs in an establishment which causes death or causes injury leading to incapacity of 48 hours or more, or is of prescribed nature, notice must be given. Notice must be given. Now, where it will be prescribed? Where it will be prescribed? It will be prescribed in rules or scheduled. Rules or schedules. Okay, rules of schedules. Then person responsible to give notice for mine, employer, owner, agent and manager. Employer, owner, agent or manager. Factory, dock work, employer or manager has to give notice. For plantation, construction, other establishment, employer has to give notice. Mode and time, notice must be sent to prescribed authority in prescribed manner within prescribed time. Where this will be prescribed? This will be prescribed under rules. Sir, where are the rules? They are under draft. They are not notified yet. They are not notified yet. Okay. So for exam purpose, you have to write this only in prescribed authority, prescribed manner within prescribed time. So we have given you ready to write answer format. If you are if you compare it from institute supplement, the language they have used, you cannot directly write that language in an exam. So we have for your understanding purpose and also for writing in exam, we have redrafted them in very calculated manner so that you can directly write this language in exam and you will find it very easy. Like reading from this language is very easy. We have arranged it in such a organized method. Inquiry in case of death. If accident causes death in plantation, building, construction work or other establishment, authority shall conduct inquiry within 2 months. If no authority specified, chief inspector cum facilitator shall cause the inspector cum facilitator to make an inquiry within the said period. Now you got two new terms, chief inspector and chief inspector cum facilitator and inspector cum facilitator. Like if there is any death in any plantation or building or construction, then within 2 days, within 2 months, the inquiry shall be made. Within 2 months, the inquiry shall be made. By whom? By the authority specified. If there is no authority specified, then by chief inspector cum facilitator shall cause the inspector cum facilitator to make the inquiry within the said period. Now, who is chief inspector cum facilitator? Means chief inspector facilitator appointed under section 34(5). What is section 34? What is section 34? So section 34 is maintenance of records, register and filing of, section number 34 is appointment of inspector cum facilitators. Okay, they are designated authorities. Define a definition of inspector cum facilitator. Now he is junior from CICF. He is junior from CICF. He is ICF. Okay, he is junior. Facilitator means inspector cum facilitator means a person appointed under section 34(1) refers to authority designated under this code, act as inspector, performs facilitative functions. Notice of certain dangerous occurrence. Section 11, notice of certain dangerous occurrences. When notice is required, if any dangerous occurrence happens in any establishment, whether causes injury, disability or not, duty of employer must send notice to occurrence to prescribed authority in prescribed form in prescribed manner. Where they are prescribed in rules and rules are not notified yet. Then notice of certain diseases. Section number 12, notice of certain diseases. If a workman contracts a disease in third schedule, sir, what is in third schedule? We will be reading this also. Okay. Employer must send notice to prescribed authority in prescribed form and time. Duty of medical practitioner. If a qualified medical practitioner attends a worker who is or was employed in an establishment and is suffering from suspected or suffering from scheduled diseases, must send a report within delay to chief inspector cum facilitator in prescribed form and manner. Sir, why they are checking their health, why they are checking their diseases, why they are checking their diseases? Sir, diseases are spread very easily. Diseases are spread very easily, like coronavirus spread like a pandemic. So diseases are spread from human to human. So it is very, very important that that workers you have employed, they're regularly checked, they're regularly diagnosed from their disease. And if someone is carrying a disease that is easily transferable and easily that can cause that is contagious. So that worker should be given a right treatment for that. The worker should be given a right treatment for that. And must send a report with chief inspector and in prescribed form and manner. If medical practitioner fails to report, then penalty is up to 10,000 rupees. Now, what is a scheduled disease? Lead poisoning, including compounds of lead and sequelate, lead tetraethynyl poisoning, phosphorus poisoning, mercury poisoning, manganese poisoning, arsenic poisoning, poisoning by notorious fumes, carbon bisulfate poisoning, benzene poisoning, chrome ulcerations or is sequelate, anthrax, silicosis poisoning, then pathological manifestations due to radioactive substances, then primary epitheliomatous cancer of skin, toxic anemia, then toxic jaundice, oil acne, bisonis, abscessosis, then occupational contact dermatitis. Like these are the diseases that can be spread from touch, spread from touch and contact, and these are all scheduled diseases. So for these diseases, you have to give notice to the prescribed authority. Okay. Then medical practitioner has to send the report to chief inspector cum facilitator. Now, how the question will come? The question will come that there was an employee working in a mine or in a factory. Then he suffered from such and such diseases. And that disease is very, very contagious. And medical practitioner failed to inform chief inspector cum facilitator. So what you will do in this case? As a compliance officer, what you will suggest the company to do? So you will suggest that if the disease is scheduled disease, you will find your disease in the schedule 3 and you will identify that whether it is a scheduled disease or it is a non-scheduled. If it is a scheduled disease, then you will say that it was the duty of medical practitioner to report it to chief inspector cum facilitator. Now he shall be liable for 10,000 rupees fine. Okay. But now he shall be liable for rupees 10,000 fine. So in this way, you can attend this question. Now, duties of employee, section 13, duties of employee. Every employee shall take responsible care of his own health, safety for himself, safety of others affected by his acts or omissions, comply with safety and health standards prescribed, cooperate with employer in fulfilling obligation under this code, report unsafe, unhealthy situations as soon as possible to employer, health, safety and safety representatives in mine agent manager under section 67, safety officers concerned official. Such person must further report employers as prescribed. Like if any employee is suffering from any disease, he should inform to his employer that I am suffering from such and such disease, so that disease is not spread all over your premises. Next is not interfere, misuse or neglect any safety appliances, conveniences or facilities at workplace for the purpose of securing the health, safety and welfare of the workers. Not to do anything willfully or without reasonable cause that may endanger self or others. Like he should be worried about his own safety also, and he should be worried about his safety of his co-workers also. He should not make anyone fall in trouble. Performs other prescribed duties by the appropriate governments. Now, what are the rights of employees? Rights of employees: right to information and representation. Employee has the right to obtain health and safety information from the employee. Like he has the right. He has to know, sir, I am working in this factory. There are so many fumes. There are so many fumes in the air. Like, are these fumes injurious to my health? Can I breathe in these fumes? So employer has to tell him that you have to take appropriate safety, you have to wear your mask, or you have to take appropriate medicine to prevent any contagious causes of these toxic fumes or anything else. Like if someone is working in a metal industry and is working near furnaces or anything else, like heat is so much there. So he can ask the employer that what are the arrangements that you have done for heat protection. Like if someone is injured from this heated metal, that what are the safety norms, or what are the first aid norms that you have carried in your establishment. He can ask that, and employer has to present, and employer has to tell it to, and employer has obligation to tell that to his employee. represent grievance regarding inadequate safety health provision direct to employer or through safety committee member under section 22 if constituted. If not satisfied, may approach inspector cum facilitator. So first of all, he has to inform a committee. Like under new codes na, there is a section of formation of committees. There is a section of formation of grievance redressal committees. Now these safety committees, now either the private organization or private establishments can form their own committee also, or they can follow the committee of government also. Okay, like government has made a common safety committee, they will make, so multiple organization, they will just follow the safety committee, that common safety committee, or they can define their own safety committee also. They can define their own safety committee also. So employer has to inform the safety committee, or if there is no safety committee, then he may approach the inspector cum facilitator. Right, in case of imminent danger, if employee has reasonable apprehension of serious injury, death or health danger, may inform employer directly or through safety committee and inspector cum facilitator simultaneously. Immediate action, employer or concerned person must take immediate remedial action if satisfied about existence of imminent danger and send a report of action taken to inspector cum facilitator. If employer has seen that the danger is real, and he is satisfied that this can really cause trouble, so he should send then he should take immediate remedial action and should send the report, action taken report to inspector cum facilitator. Dispute in danger, if employer does not agree about existence of danger apprehended by employees, must still refer the matter to inspector cum facilitator. Decision of inspector cum facilitator is final. Like if the employer find that my employees are doing are very negligent towards their work, I do not believe them that that a real danger exists there. So in that case also he has to refer the matter to inspector cum facilitator, and it is up to the inspector cum facilitator to define that whether the danger existed or not. And decision of that inspector cum facilitator will be final on them. Then next is section 50, duty not to interfere or misuse. General duty, no person shall intentionally or recklessly interfere with, damage or misuse anything provided for health, safety, welfare under this code. Like I have given you the example. That person should use the tools very safely. Do not use the tools for wrong purposes. Okay. So this was for this session, and we will be continuing with our next chapter in our next session. Make sure you subscribe the channel, and make sure you avail these books as soon as possible, because your exams are really near and you have very less time to cover this. For all the self-study students, we have prepared this ready to write study material, and this study material, this is your Focus Lexicon Labor Law Architect, and this book is a really very good resource for your labor laws paper. And second book is your labor laws case law digest. All the case laws are covered in ready to write answer format. All the case laws are covered in ready to write answer format, and we have also given master index in these books. So these books you can refer for your exam also. Open book exam is all about study material. So all the very best for your exams, and keep learning and keep growing. Thank you so much.